Hello, and welcome to the fifth and final part of our video lecture series on Module 2, which is on the leasehold arrangements under RA 3844, otherwise known as the Agricultural Land Reform Act. Okay, now in the previous video, we discussed the grounds of dispossession, and after having discussed those grounds which need more discussion and clarification, we differentiated termination from dispossession. We said that termination and dispossession, they are both uh, means to extinguish, to sever the relationship, agricultural leasehold relationship between the agricultural lessor and the agricultural lessee, but they differ on some aspects. For example, termination does not need court approval, while dispossession does require court approval, and therefore the invocation of the grounds must be supported by evidence, must be proven by sufficient evidence as required by the courts. Okay. Now, in this fifth and last video, we will discuss other relevant rights. Now, we have been discussing all the rights and privileges in the previous discussions in connection with the other topics, but there are other guaranteed rights. Note that there are many rights guaranteed under RA 3844, but in order for us to identify lang some relevant rights, very important rights vested under RA 3844, let's discuss some of them, no, which are for me relevant and are useful for our learnings. First, uh, right is a right to a home lot. According to RA 3844, an agricultural lessee, di ba, shall have the right to have specific portions of the area for residential purposes. Okay, the area where he or she made residential na mga improvements are considered to be included in the area leased. Note that, no, if we recall, uh, there's this ground for substantial for breach of contract diba? It's a ground for dispossession. Now, one of the elements, I mean, one of the aspects of breach of contract is deviation from crops agreed and use. No? The primary use agreed in an agricultural leasehold arrangement is for cultivation of land. No? Cultivation of the land for fruits to be produced, right? Such that if the primary use is agriculture or cultivation, do we say therefore that residential is outside of that? No? Uh, Perhaps the crafters of the law saw this one, and in order to clarify, in order to make it clear to both parties and to the public uh, that it does not make sense, no, to have an agricultural lessee in an agricultural land and then not allow the agricultural lessee to have some place to stay, to rest, no, or to live in. Uh, or to require the agricultural lessee to live outside of the agricultural uh, I mean sorry agricultural land leased. Okay, such that here in this specific provision of RA 3844, uh, the right to a home lot is guaranteed, meaning even though the primary use agreed under the leasehold arrangement contract is agricultural, the agricultural lessee is not barred from using a portion of the land leased for his or her and his or her family's residential use, because lagi they are guaranteed the right to a home lot. And this area, according to the law, this area where the home lot is constituted is considered as included in the area leased. Okay? Now, very simple ang right to a home lot. Very simple lang na siya, but it has to be discussed because there may be questions ng attorney, di ba? Deviation from use, but the use is agricultural, but then naghimo siya balay diha. Is that a deviation from use? Uh, Technically, it's deviation from use, but it cannot be considered as a ground for dispossession because it is a right that is guaranteed by the law. Okay? Uh, dili man dili man na siya agricultural good because it's residential purposes. So it's not within the use agreed upon. But still, because it's guaranteed by the law, then it cannot be considered as a ground for dispossession. A very simple lang si right to a home lot. No? For the reason that it does not make sense to require him or her to not have to live outside the land, no, where he or she is stealing, or to prohibit him from building shelter in the land lease. Okay? It's an essential manggod ang shelter. Very simple ang right to a home lot. And let's proceed to right to preemption and redemption. Okay? Preemption and redemption, these are rights that are granted under RA 3844 in order to address that very valid concern of what if attorney, what if the landowner, in order to circumvent all the rules, all the privileges under RA 3844, just sells the property to another person. What if attorney, in order for the landowner to get rid of the the land, I mean the agricultural lessees, the landowner will just dispose of the property to another person. This right to preemption and redemption are guaranteed by RA 3844 to address specifically that scenario. No? What are the rights to preemption and redemption? Okay. We can answer that question, okay, by first preliminarily making an illustration. Okay, we illustrate this with the fact that uh, with the fact that an owner or person who is an owner enjoys, of course, no ownership, and because there's ownership uh, on the part of the person, he also enjoys all the attributes of ownership, such that possession, right to use, fruits, etc., etc., also pertain to the owner. But again, because the owner has the right to dispose the property or some rights in relation to the property, some attributes of ownership, the owner, therefore, may also transfer possession of the land, no, while retaining ownership to himself or herself, right? No, so in fact, this is the case of an agricultural leasehold, right? Now, wherein the owner will transfer possession, use, and entitlement to the fruits to another person who is called the lessee, agricultural lessee, while the owner, the lessor now, retains ownership, retains the right of ownership. Okay. Now, since only possession, only the use of the land, only the fruits, entitlement to the fruits of the land are transferred, the owner retains the right of ownership, including the right to dispose of the property. That means even if the lessor entered into an agricultural leasehold contract with the agricultural lessee, thereby transferring the possession to the lessee, the lessor may still validly dispose of the land, may still validly sell the land, even though it is under the possession of an agricultural lessee. Now, therefore, the owner will become the seller, no? And the another person will become the buyer, and the buyer will now have ownership over the land. But because the possession, the use of the land, and the right to the fruits of the land have been transferred to the lessee, what will happen now to that arrangement, to the leasehold arrangement? And what will happen to the lessee, right? What will happen to the lessee who was given the right to possession, the right to use, and the right to entitlements to the fruits of the property? Okay. Now, the answer is that the buyer now, who is the owner, will assume the part of the lessor, right? The leasehold relationship will still subsist, right? But another effect, in case the owner sells the land to another, is that there arises rights on the part of the lessee in relation to the land. And these are what we call, the uh, rights of preemption and redemption. Now, preemption and redemption, they pertain to a scenario where there is either an intended sale of the property, or there was already a sale of the property. No? Preemption, di ba? Preemption, it's before the sale, while redemption, it's after the sale. And there are rules, no, when they can be uh, exercised. Now, I would just caution you, because when you reach siguro third year first sem, or perhaps second year second sem, but you will take now mga, for example, international business law and banking law, you will encounter similar nga mga notions on preemption and redemption. Siguro you will discuss also in your credit transactions gani, no, kanang preemption and redemption. I'd just like to caution you that all those mga preemption and redemption governed by the civil code or by the banking laws are different. No? Different from the right of preemption and redemption under RA 3844. Let's just get it out of the way, no? Na para we know that when we talk about preemption and redemption in relation to RA 3844, there are different rules and different requirements. All right? Okay, sige. So, let's start with preemption. Okay. Now, what are the requirements? What are the requirements in order for the right of preemption to be exercised? Of course, under the law, under RA 3844 as amended by RA 6389, the landowner is duty bound to notify the Department of Agrarian Reform and the lessees of the intended sale about the intended sale. No, there has to be notification not only to the DAR but also to all the agricultural lessees in the area intended to be sold. Note, no, it's intended sale because it's a right of preemption. The sale has not yet happened. No, the law requires the landowner to notify the DAR and the lessees of the intended sale. Under the amendment to RA 3844, of course, the lessee will get a memo or a notice, no, that the land is about to be sold by the landowner. If the lessee wishes to preempt, meaning if the lessee wishes to buy the property, no, instead of another person, no, the reason being that the lessee is given the right of first refusal. Now, if the lessee wishes and is capable of buying the property instead of another person, then the lessee must give notice of such intention to the land owner. Okay. Note, if there are more than one lessee, there's more than one lessee. Now, preemption must be limited to the respective actually cultivated areas. Now, there's no problem if there's just one lessee. It has to be the entire area, no, cultivated, that must be preempted. That must be purchased. But if there's several of them in lessees, several lessees, then uh, limited siya to the respective area actually cultivated. And who will determine that? Of course, it will be uh, the court. It will be the court who will determine that with the aid also, of course, of DAR and with sufficient evidence. Note that as a rule, okay, this notice of intention by the lessee must be sent. Okay, meaning this right to preemption must be exercised within 180 days from notice thereof. From the time he or she is notified, is given a written notice of the intended sale, the lessee must exercise this right to preemption within 180 days from notice. And this is what will happen. No? It's just general flow. No? Just to give you an idea. The whole process is much more technical, which we will not go into, since this is a course that is geared towards introducing the basics of the law. So when there is an invocation, when there is an exercise of the right of preemption, what will happen is that there must be notice of intention to preempt, no, 'di ba? Within 180 days, right? Now, uh, the under the amendments to RA 3844, the agricultural lessee has two options to pay. He or she may pay, no, if he or she has the cash. He may pay in cash, of course, or he or she may loan from the bank. Okay, but not just any other bank. Under RA 3844, the recognized bank who may give loans in such a case for preemption would be the Land Bank of the Philippines, no? Land Bank of the Philippines. Now, if in case the agricultural lessee has wants to pay in cash, then the notice of intention must be coupled with tender of payment. Okay? Must be tendered, di ba? Notice of intention, and then sa ubos niya na kwarta. Okay? Notice of intention, and then there is notice of payment. But in case the agricultural lessee does not have enough cash, no, and wants to loan from the Land Bank of the Philippines, it's also possible. And what will happen is that the agricultural lessee, given the 180 day period, the agricultural lessee will have to undergo the process of the bank, and ultimately he or she will be issued with a certificate of payment from the Land Bank. No, that certificate of payment essentially states that the Land Bank of the Philippines, will pay you, landowner, for the reasonable price of the land, and then it is the agricultural lessee who will own the land. Of course, in that certificate, there is a promise. There is a promissory note, or a sort of arrangement between the agricultural lessee and the bank, no, for the amortization of the amount loaned. Okay, and then of course, that's a common banking practice to have the land, have the real property asset to become the collateral for the loan. Okay? Now, if, for example, the notice of intention was given, even with the certificate and the tender of pay and cash, the landowner refuses. No? If, for example, the landowner refuses to receive the notice of intention because he or she does not want the agricultural lessee to own the property, he wants the third person to own the property. Okay? What will have to be done by the agricultural lessee is to consign either the cash or the certificate of payment from land bank with the court. Okay. And then we will not discuss anymore the rules on consignation. I think you have already learned this in your obligations and contracts. But essentially, because the landowner refuses to receive the payment, you go to court in order to deposit the amount, the reasonable amount, or the certificate from the land bank, in order for the whole uh, act of preemption to be complete. Okay? In order for the whole act of preemption to be complete. Why? Because according to the court, okay, uh, sorry, according to the court in Castro versus Mendoza Senior in 2017, although this is on the matter of redemption, okay, it seems to be that uh, in cases where there is uh, an exercise of the right of a lessee, no, either for redemption or for uh, preemption, tender or consignation is an indispensable requirement to the proper exercise of these rights. Tender, if for example, gi-accept, or consignation if wala gi-accept. No? Specifically, for the right of redemption, no, kailangan na siya na ay tender or consignation, not only the intention letter. Okay? Uh, so that's the general flow. Very important because and for notice for the right of preemption to be complete, there has to be notice to preempt to landowner, and there must be tender of payment or presentation of the certificate from land bank. Okay, which is recognized by the law to finance no the rights of preemption and redemption. And if the landowner refuses, then you go to court to consign the tender of payment or the certificate from land bank. And only after only after the agricultural lessee fulfills these conditions, does the right of preemption become complete. Does the exercise of the right of preemption become complete? Okay? Now that's for the right of preemption. Again, we repeat, no, that under the law, landowner is uh, duty bound to notify of the intended sale. But if uh, after the notification, the lessee will have 180 days to from notice to give the notice of intention, of course, with tender of payment or consignation, as the case may be, and then the as a general rule, if there's only one lessee, the whole area leased must be preempted. No? If there are more than one lessee, uh, the preemption is limited only to respective na mga actually cultivated areas. Okay, that's for preemption. Now let's go to uh, redemption. Now, redemption, on the other hand, redemption is when the sale was already done and the sale was not subject of a notice. Okay, the sale was not subject of a notice from the landowner. It can be. It can be that the landowner may disregard that duty posed by the law, thinking perhaps that, oh, I will not give notice in order for the agricultural lessee to not have any opportunity to own this land. So addressing that scenario, no, addressing that potential scenario, potential machination of the landowner, the law RA 3844 as amended does not only grant the right of preemption, it also grants the right of redemption over agricultural lessees. No? Uh, in redemption, here, no, the leased land was sold without the knowledge of the lessee. Okay, without the knowledge of the lessee, uh, uh, the leased land was transferred or sold to another person. Okay. Now, when will redemption be done? The leased land was sold. The leased land sold without the knowledge of the lessee may be redeemed within 180 days from notice, not by the vendor but by the vendee, not by the seller but by the buyer. Meaning, we have here a land which is leased to a specific person, and this land was sold by the landowner to another person. And this another person, now the owner, realizes, uy, there is a lessor, there is an agricultural lessor in the land that I got, the land that I bought. Okay? This new owner, the buyer, will have to notify the agricultural lessee, no, uh, that the land was already sold to him or her. Okay? Now, that 180 days will have to Kaning, it starts from the day the vendee or the buyer gives notice of the sale to the agricultural lessee. No? Of course, redemption must be on the entirety of the land. Of course, just like preemption, if one lang entirety of the land na leased, unless there are more than one lessee, in which case, uh, the 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 extent of the redemption must be uh, in so far as they cultivated the property, no, respectively. uh, of course, redemption that is initiated by a petition or request filed in dar, no? Request filed in dar, or a petition filed uh, in court. Okay, and what will happen is like this, no? The general procedure is like this. Okay, here we have diba? Sorry. Okay, let me back up a little. Okay, so here, redemption, no, attorney. What if, for example, no, uh, the land was sold without the knowledge of the lessee, uh, and then the landowner sees, "Oy, there's an agricultural lessee," but we will not notify the agricultural lessee. Otherwise, he will have, or he or she will have the right of redemption. So let's just not notify them. Okay, and then wait. What will happen? Okay. Now, in this case of Po et al. Versus Dampal, the court said that, the admitted lack of written notice in the DAR, it told the running of the prescriptive period, diba? That means the 180 days, it does not run. No? It does not run because the requirement of the law is that there must be written notice by the vendee, and then the 180 days will have to start from the receipt of the notice. Now, without the notice, the 180 days will not run. And therefore, as long as there is no notice from the vendee, then the agricultural lessee may still redeem the property. In this case, Manggod of Po et al. Versus Tampal, no notice by the vendee was done. No? But then, the certificate, the deed of sale was already registered with the RD. And the RD, of course, na-register na sa RD, and in your land titles and deeds, when there is a voluntary transaction, uh, that transaction will have to involve the surrender of the owner's certificate of title of the buyer. Okay, and then i-cancel na siya, and also i-cancel po ang copy nila, and then new ones will be issued in favor of the of the previous owner, no, i-cancel ang certificate of title, ang owner's duplicate, uh, sa previous owner, and then a A new one will be issued to the buyer now, no? Which now contains the name of the buyer as the owner. According to the landowner here in this case, he said, okay, we did not give written notice, but the lessee should have should have gained constructive knowledge, because the certificate of sale was registered already. In fact, there was already a certificate of title issued to us, and under in the land titles under the doctrines and rules of the land titles and deeds, this registration of certificate of sale and the uh, this certificate of title issued to us, that's constructive knowledge to the whole world that we are now the new owners, and therefore the 180 days should have been from the registration of the certificate of sale. Now, according to the court, okay, no, that's not the rule anymore. That's for the old rule under RA 3844. That was already amended by RA 6389. Okay, and according to the court, the law is clear. The 180 days must be reckoned from from the time the written notice from the vendee has been received. Without the written notice, uh, the running of the prescriptive period will not start, and therefore the contention of constructive knowledge fails, no? Because there is an express requirement of a written notice. Okay? Now, this is what happens when there is an exercise of redemption. Okay? Diba? There must be notice of intent to redeem. Uh, that notice of intent to redeem uh, may be done if diba, for example, it's there is now a notice from the vendee, no, 180 days. Uh, but if there's no notice, but still you learn about the sale, the 180 days will not start, but still you can redeem, no, because of the case of Po et al. Versus Dampal, no, lack of written notice will not start the running of the 180 days, but still you may redeem. Okay, there are two modes, no, for you to redeem. First, you may redeem it. You may redeem the property leased by tendering a notice of intent to redeem. Okay, of course, it may be through cash or through financing or loan from land bank, in which case there has to be a certificate. Okay, and then there has to be consignation with the court. Now, note, consignation with the court, regardless of whether the court whether regardless of uh, there is court petition for redemption or not. No, as long as the landowner refuses to receive the proper the tender of payment. Okay. Uh, Redemption may also be done not by giving notice of intent to redeem, okay, but by filing directly a petition for redemption in court, okay, and it can also be through cash. Of course, you have to deposit the cash there, uh, or yeah, consign the certificate from land bank. Now, what is the difference between a notice of intent to redeem and filing a petition for redemption is that if you file a notice of intent to redeem, you go to the DAR, okay, and the DAR will have to institute a petition in court, okay. But if the agricultural lessee wants to directly go to court, he or she may also do that. Okay, file directly the petition for redemption, and then at the option, of course, pwede cash, pwede siya financed by land bank, and then if the landowner refuses, of course, there must be consignation. Okay, that's just general flow of redemption under RA 3844. Of course, we said that the tender or consignation, no, tender of money, no, or the certificate of from the land bank, uh, or consignation if they refuse, they these are indispensable requirements to the proper exercise not only of the right of redemption but also the right of preemption. Okay, now those are the rights, okay, to uh, preemption and redemption. Now, from the right to a home lot to right of preemption and redemption, we now go to the right to acquire the land holding. Now, in this portion of the law grants the right uh, to the agricultural lessee to acquire the land holding even though there is no sale, there is no intended sale to third persons, no. Right to preemption and redemption, they presuppose that the land was either sold already to the third person in case of redemption, or the land is about to be sold to a third person, no, in case of preemption. But regardless, no, and notwithstanding the absence of the fact of sale or an intended sale, an agricultural lessee may also have the right to acquire the land holding. And how to do that according to RA 3844? The agricultural lessees, they may file a petition in writing with the then Land Reform Authority, now DAR. Okay? They may file the petition to acquire the land holding, and now the DAR, or the formerly Land Reform Authority, will now have to institute expropriation proceedings with the courts, whereby the Land Reform Authority, or whereby the state, through the Land Reform Authority, or now DAR, will acquire the property first from the landowner, and then, of course, there's payment of just compensation, and then now the DAR, or the Land Reform Authority, will turn around and grant ownership to the agricultural lessees. Note, under the law, it presupposes that it requires that the majority of agricultural lessees in an agricultural land holding is required to file the petition in writing. Attorney, what if isa lang? Of course, isa lang ka, and you file a petition, that's 100%. That's more than majority. So it's perfectly permissible. Of course, as long as you are the agricultural lessee is able to pay the necessary charges, pay the necessary costs for the acquisition of the land holding. Now this is a right, no? This is a right that resembles closely to the current agrarian reform framework nato, no, under Carl. But note, okay, this right to acquire land holding is just an option. It's just a feature, small feature of RA 3844. It's not the main theme of RA 3844, whereby the land holding may be acquired by the state and then, diba, given to another person. The same is not true with other mga laws, subsequent laws, specifically ang uh, Presidential Decree number 27 and ang RA 6657, because their main theme na karon sa PD 27 and RA 6657 or CARL is the acquisition mismo of the land holding. Not anymore leasehold first and then you may acquire, no? PD 27 and specifically RA 6657, it's acquisition. Acquisition of land and then distribute to the farmers and beneficiaries. Okay? Again, under RA 3844, the main theme is agricultural leasehold, One of the features lang is the right to acquire the landholding, provided that majority of the agricultural lessees in the area will file a petition in writing with the LRA, Land Reform Authority before, but now DAR. Okay, and in which case the DAR, the government, will exercise its power of eminent domain to acquire the land holdings and then distribute it to the agricultural lessees. All right. Now, we are now on the last portion of our discussion on RA 3844. No? The last portion is the legal status of RA 3844. We note that RA 3844 was one of the earliest, no, after tenancy laws. RA 3844, no, leasehold arrangements uh, was put in place as a remedy to the several abuses of the tenancy relationships. Now, after 3844, there's Presidential Decree number 27, and then, of course, there's this RA 6657, or the CARL, as amended, no? The CARPER, no? Yung pang-extend. We then ask, uh, RA 3844, PD 27, and RA 6657, they are all on the same subject, meaning they're all in the same category as agrarian reform laws, right? Now, there are rules in RA 3844 which may not be consistent with the rules of RA 6657, right? For example, the rules on conversion, the rules on classification, in terms of termination of agricultural leasehold, uh, different na siya from unsay naa sa 3844, it's different na with RA 6657, right? Now, we recall then our discussion, or for example, our your learnings in statutory construction on implied repeal. No, implied repeal. Is there implied repeal here? No, since there are subsequent laws on the same subject, and there are different rules governing specific na mga topics, specific na mga areas of law. In short, we ask, is this RA 3844 still effective, given the fact that there are several subsequent laws on the matter? Okay. Now, in the case of Reyes versus Reyes, no, in 2002, the court had this opportunity to declare and to make an assessment whether there is an implied repeal of RA 3844. In this case, according to the court, no, uh, if the relationship is an agricultural leasehold arrangement, then the governing law is RA 3844, right? This RA 3844, although old, although there are subsequent laws already, this was not specifically repealed by the subsequent laws. This was not specifically repealed by the Comprehensive Agrarian Reform Law, or the CARL, or the RA 6657. And in fact, according to the court, there's no implied repeal in this case, because there's no fundamental inconsistency with the provisions of RA 6657 and uh, RA 3844. Except for section 35, no, ano lang nga provision under RA 3844, except for that specific provision, okay? RA 3844, the rest of RA 3844 is still considered as effective, no? There's no implied repeal, because the policy, as we remember, the policy, in case there are seemingly two laws that deal with the same subject matter, is to harmonize, right? The policy is not to declare immediately implied repeal. In fact, diba, we recall, implied repeal that is frowned upon in our jurisprudence. And the only time when we can say that there's implied repeal is when that there are two laws on the same subject matter and the provisions are fundamentally opposite or diametrical to one another, such that the other law, which is the older law, must be considered to have been impliedly repealed by the new law. But here, according to the court, are the provisions of RA 3844 are not diametrically opposed to the provisions of RA 6657 or the Comprehensive Agrarian Reform Law. In fact, according to the court, no, the intention is to have RA 3844 is to give RA 3844 suppletory effect to RA 6657, is to have is to fill in uh, the the law, no, in cases where the scenarios are not covered by the provisions of the CARL, not covered by the Comprehensive Agrarian Reform Law. Okay, attorney, you said that the rules in RA 3844 in terms, for example, of uh, classification or reclassification and conversion of land are different with the rules on uh, reclassification and conversion of lands under RA 6657. How does the Supreme Court not say that there is diametrically opposed provisions? The court, in as we go along, as we discuss in our module 4, no, RA 6657, the court took an approach of harmonizing the two instead of declaring an implied repeal. The court did that by setting the effectivity of RA 6657 as a time period separating the rules of RA 3844 and PD 27 and the rules of RA 6657, such that, as we shall learn in Module 4, no, the applicability of the new rules under CARL start from the time CARL took effect. It does not apply from before. It does not apply to cases before the effectivity of CARL. Okay, that is how the court harmonized them, such that under our jurisprudence, and this is what we accept right now, RA 3844, except for Section 35, was not specifically repealed. No, it was intended to have suppletory effect, and it is still now. It is still in effect as suppletorily as a suppletory law to RA 6657. So, attorney, if the framework now is to transfer, I mean to acquire property and transfer or redistribute them to tenants, redistribute them to the agricultural lessees, how then can a leasehold arrangement still subsist in that regard? Now, given that RA 3844 still exists, no, it can only exist now in the following circumstances. Okay, first, the leased areas, I mean the retained areas by the landowner. You know, in as I have already been alluding to several times, because also there is protection of the rights of the landowner. The law, Agrarian Reform Law, RA 6657, also recognizes retention rights. No, PD 27 also recognizes retention rights, meaning those land holdings which the landowners may keep for themselves, no, which are outside of the operation of the acquisition and distribution. Now, these lands retained by the landowner are still owned by the landowner. And if these lands are still owned by the landowner, they can therefore lease these lands. Okay? And therefore, if they lease these lands, they can enter into agricultural lease to those lands or a civil law lease to those lands. But in case they enter into agricultural lease, these the relationship of agricultural lease in these retained areas will be governed by RA 3844. Or, ani, very unlikely, but it can still happen. No? A farmer beneficiary, acquires land, right? But then, after having cultivated the land and after having siguro, uh, improvement in life status, improvement in siguro the children are already professionals or abroad, and then they want to go out of the province, for example, and then the farmer beneficiary does not anymore cultivate the land for himself, but now the farmer beneficiary is the owner. In order to keep agricultural activity in the land, the farmer beneficiary may enter into an agricultural lease contract. No? Now, in that case, no, agricultural lease man siya, it will be governed by RA 3844. Also, again, there is this, as we will discuss in RA 6657, there's this sanction on farmers cooperatives, no, farmers cooperatives wherein farmers will pool together their resources including land and then form their cooperative under the Cooperative Act of the Philippines, Cooperative Code of the Philippines. And then this farmer cooperative will have its own juridical entity, and therefore, since it's a juridical person, and as we have discussed, no, an agricultural lessor may be an maybe a juridical person, no, this farmer cooperative may enter into a leasehold arrangement contract with at with agricultural uh, corporations. Okay. Yes, agricultural. No, no. This is not agricultural corporations, because agricultural lessees are only natural persons. So they lease it with agricultural lessees. This is a typographical error. They lease it to agricultural lessees who are natural persons. Okay. Again, leasehold can only exist now and can only be governed by RA 3844, notwithstanding the effectivity of RA 6657 or the CARL in cases where the retained areas by the landowner are leased, are subject of an agricultural lease. When the farmer beneficiary enters into an agricultural lease with another person, or the farmers cooperative uh, lease leases the land awarded to them. Okay, and then the lease will be to agricultural lessees who are natural persons. Okay, so that's the end of our lengthy presentation and discussion in Module 2. Next module will be on Tenant Emancipation Decree or Presidential Decree number 27. Now we will discover a framework which approximates an acquisition distribution framework of agrarian reform law before we go to our current framework, which is on RA 6657. Thank you for viewing our video lectures and see you for Module 3.